All right, well, let's get started. For those of you I didn't see in the last section, my name's Jamie Olin. I'm an attorney here in Dallas. And in this session, we're going to be talking about the rules of evidence and making objections. So before we get into it, just a couple of small things. I'd ask that everybody stay on mute during the presentation. Using your camera or not is completely up to you. I'm fine if you want to keep your camera off. And I'm going to ask some questions of the group as we go along and get some ideas from everybody. And I'll just ask you to put those in the chat as we're going along. So we'll be brainstorming together, we'll be answering some questions together, and we'll just do that by using the chat. All right. So we, in the first session, touched a bit on evidence and maybe even talked a little bit about objections and why those are important. We're going to go into more detail about that now. So first, what is evidence? And it's a question that I think we all use the word evidence in all different kinds of situations. But for mock trial and for the law specifically, evidence has a very firm meaning. What evidence means is facts or information that help determine whether an assertion, whether it's a statement or a document, is true or valid. So basically, it's any information that is going to help the jury decide whether something is valid, whether it's the case itself. So in this example, we're going to be talking about a murder case. So evidence would help to determine whether the person who's on trial for murder was actually the murderer. So in this case, that's what we're going to be doing. So the example we're going to be using here is the defendant, or the person who's accused of the murder, claims he did not murder his roommate. So that's the very basic thing that we're going to be dealing with in this session. So what evidence would support the defendant in his assertion? So the different types of evidence that could be valuable here would be any eyewitness testimony that the defendant was not home that night. Because if the roommate was murdered in their home, but the defendant wasn't home, then that's really valuable for the defendant's case. A receipt from a bar with a timestamp showing that the defendant was there. So again, that could be really valuable because it would show that the defendant, again, wasn't in their house. The butler's text message stating, "I'm about to be murdered by my sister." And so in this case, if the sister is not also the roommate, then we've got another person who committed the murder instead of the defendant. So that would also really help the defendant. Let's say there's a book in the sister's apartment that's titled "How to Murder Your Brother and Get Away with It." That would lend some additional evidence to the fact that maybe it was the sister who did the murder and not the roommate. Fingerprints on the murder weapon that would match the sister and not the defendant's fingerprints. So again, that could also be very valuable to help the defendant because suddenly the defendant is not the one who's being accused of the murder because the sister's fingerprints are the ones that are at issue here. And I'm sorry, I'm moving this around just a little because I couldn't see the chat and I want to make sure that's up. But let me try it again and make sure we can see that also. Sorry, just 1 second. All right. All right, we're just going to have to do it this size instead. Okay, so the rules of evidence. Every state has its own rules of evidence, and mock trial has its own rules of evidence too that are loosely based on the Texas rules. So why are rules of evidence important? Well, for one thing, if you didn't have any rules governing evidence, then you would have all sorts of testimony and all sorts of exhibits coming in, whether they're relevant or not. That could be a big problem because it could make a trial that only needed to last a day or two go on for a very long time. So one reason that the rules of evidence are important is to keep all that irrelevant testimony out of the trial. It also helps to keep fake exhibits out of the trial. So we want to make sure that if there are documents or a murder weapon or anything else like that coming into evidence, that they're real, that they're authentic. And if you don't have the rules of evidence, then there are no real ways to be able to determine whether the exhibit is true and correct. And so that's one of the things that the rules of evidence guarantees. Ensures that the jury is hearing from the right witness. And so this goes to when we start talking about some of the specific rules, whether the witness has to speculate about what happened or whether they have personal knowledge about what happened. And the testimony that comes from somebody with personal knowledge is a lot more valuable than if it's coming from someone who wasn't there or has to speculate. And then just in general, it keeps the trial from turning into a circus. Because if everything is coming in and everybody can say whatever it is they want, then there's no way for the jury to really be able to decide the case. So we have a question about, are the rules of evidence in a civil case different from the rules of evidence in a criminal case? Generally, they're the same. In Texas, they are in the same part of the code, but there are differences within that. And when I say code, I mean the big book that lists all the different laws and rules. But sometimes if you're looking at those rules, there are some differences, and those are specific. So it'll say something like, here's the rule. In a civil case, it's different in this way. In a criminal case, it's different in that way. So you find them all in the same place, but then sometimes it does drill down on those differences. Okay, so the first thing I'm going to talk about is this issue called judicial notice. And this is something that arises in mock trial every once in a while. Basically, this means that a judge can take notice of a fact that is generally known or can be easily determined from accurate sources. And so sometimes in the mock trial problem, you will get it will tell you right in there that there is judicial notice taken of these facts. And basically what that means is that they're facts that are not in dispute. They're very important to the case, but they're not something that could be reasonably disputed. And so at the beginning of trial, during trial, you can ask the judge to take judicial notice of those facts so you have them and you can rely on them, but you don't have to put in evidence to support them. So for example, could be something like on June 20th, 2019, the sun rose in Dallas at 6:19 a.m. That's something that a judge can take judicial notice of because it's something you can look up in an almanac. You can look it up from a reliable source on the internet. There's no dispute about that. And if that's a fact that's important in your trial, then you can ask the judge to take judicial notice of that fact. A couple of other examples, ice melts in the sun. That's not something probably anybody's really going to dispute. It's a scientific fact. The earth is round, or the Cubs won the World Series in 2016. Again, you can look to a history book, you can look to reliable sources on the internet. It's something everybody would agree to. And so if it's a fact that's important to your case, you don't need to put on additional evidence to support it. So you have the question, what are the limits of judicial notice? It's a great question. Basically, anything that the two sides and the judge would not necessarily agree to. So let's say it's something about whether a certain celebrity is dating another celebrity. You could say, well, you know, TMZ or the internet says that they're dating, but then the other side could say, well, that's not a reliable source. So you probably wouldn't be able to take judicial notice of a fact like that because the sides wouldn't agree that it's reliable. And so courts can take judicial notice on their own. They can just decide to do it, or the parties can ask the court to do it. And in mock trial, usually that'll be in the problem, and then you just have to introduce it during the testimony to ask the judge to take judicial notice of those facts. The next really important concept for evidence is relevancy. Because again, we don't want the trial to turn into a circus. We really want all the evidence to be relevant. And so under Texas law, evidence is relevant if it makes a fact more or less likely than without the evidence, and if the fact is important in the trial. So in the case we're talking about in this presentation, the question is whether the defendant murdered his roommate. So important facts for this trial would be things like, where was the defendant on the day of the murder? What was the relationship between the defendant and the roommate? What was the murder weapon? Things like that. And so relevant evidence would be anything that would make one of those facts more or less likely. So let's say that the murder weapon was a very heavy lamp that the defendant is accused of hitting his roommate with. Well, then if you wanted to introduce relevant evidence about this, a receipt that shows that the defendant bought that lamp is something that would be very relevant, because it would go to first the murder weapon and that the defendant actually bought the murder weapon. That would be an example of relevant evidence. Evidence that is irrelevant is not admissible at trial. Again, we don't want the trial to turn into a circus. We don't want it to go on much longer than it has to. So we limit trials to relevant evidence. Relevant evidence, though, even if it's very relevant, can also be excluded under certain circumstances. And that's usually when it's relevant, but introducing it could also mislead the jury because it's confusing, could also prejudice the defendant in certain ways by maybe showing that, yes, he bought the lamp, but the video camera footage of him buying the lamp shows that he was with somebody he wasn't supposed to be with at the time. Something like that could be prejudicial to the defendant, and then that's an objection that you could make during trial to try to exclude that evidence, even if it's relevant. We'll talk more about the objections in just a minute. So again, here's some examples of what relevant evidence would look like in the case we're talking about. So any of these could be relevant. So video footage showing the defendant buying the lamp, an autopsy report showing that the roommate died from blunt force trauma from being hit on the head with the lamp, text messages between the defendant and his roommate showing they'd been fighting about doing dishes, and then maybe even testimony from the defendant's mother saying that he hated doing dishes more than anything else. All of these facts would be relevant. All of this evidence would be relevant because it might make the fact that the defendant was the murderer more likely than not. But what kind of evidence would be irrelevant in our case? The defendant's eye color, the roommate's favorite type of zoo animal, where the defendant went to elementary school, etc. I mean, the universe of irrelevant evidence is huge, and it's what you would want to stay away from unless there's a way you can use it to lead into the relevant evidence. But in our case, none of this stuff matters, so none of this evidence would come in. Okay, I'm going to talk briefly about character evidence. This is complicated, so I'm not going to go into great detail about character evidence, but basically under the law, you can't use evidence of a person's character, of their personality, reputation, things like that, to prove that that person acted in that way on that particular occasion. So let's say that you're somebody who's known our defendant his whole life, and you would say that, you know, he tends to get really angry just out of the blue. He tends to have an aggressive kind of personality. You can't use that testimony to prove that means he acted in that way on the day of the murder, because that's very prejudicial to the defendant to do that. There are some exceptions there, though. So the defendant could offer evidence of his own character trait. So if our defendant is testifying on his own behalf, then he could offer evidence that he always tells the truth. That's okay. And then in a murder case, which is what we're looking at here, the defendant could offer evidence that the victim, so here the roommate, is actually very violent to help prove self-defense. So in our case, the defendant could testify that the roommate has a history of violence. He's been arrested before. He's just always been very aggressive toward me, to try to prove that he only murdered the roommate in his own self-defense. And a witness can testify to a defendant's character if that witness was familiar with the defendant before the day of the crime. So if you're going to bring in character evidence to help the defendant, then you need to make sure the witness that evidence is coming through is friend or family or a teacher, somebody who's known the defendant before, not somebody who met the defendant in jail or ever since the arrest happened. That doesn't come in through the rules of evidence. So what can witnesses testify to? What kind of evidence can witnesses bring in? So they have to have personal knowledge of the matter they're testifying about. Now, this doesn't apply to experts. So let's say we're talking about a case where we have a forensics expert, somebody who can testify about DNA or fingerprints. they don't have to have personal knowledge. They don't have to be an eyewitness, somebody who saw what happened. They can offer opinions about that fact because they are being used as an expert in the case, which basically means that they have the background, education, and experience to be able to see the murder weapon and offer opinions about it. But other witnesses, who we call lay witnesses, because that's the opposite of an expert, they can't offer opinions like that. They would not be able to say, yes, this was the murder weapon, because they didn't do the DNA analysis. They're not an expert on DNA. What they can do is say what they saw, what they heard, and maybe talk about the defendant's character, but they can't offer any opinions as to what actually happened in that case. They have to have personal knowledge. And then a witness's credibility can be attacked or supported by whether or not that witness has a reputation for lying. So let's say we have a witness who says, yes, I saw the murder, I saw the defendant do it. Well, then maybe the defendant can bring in a witness who says, yeah, I mean, I've heard that witness's testimony, but I've known that witness my whole life, and they lie all the time. So that's something that can happen too. All right, I'm going to talk briefly about hearsay. Hearsay is probably the most difficult evidence concept. I think if you talk to lawyers who have been practicing their whole lives, most of us would say, hearsay, nobody really understands it fully, but everybody understands it enough to recognize it when it happens. So before I go into that, there was a question of how can someone be deemed an expert witness? So typically what happens, and what happens in mock trial, is say you have a doctor, somebody who treated the roommate in this case before they died. Then that doctor, because they have the education, let's say they have 10 years of being a doctor, they could be an expert in medicine. And so what you would do is ask the judge during mock trial to qualify that witness as an expert in medicine, if that's something that could help you. And so it really comes down to education, experience, and qualifications in a certain matter that's important to the trial. So back to hearsay. So hearsay is a statement that somebody made outside of trial that a party offers into evidence to prove a matter asserted or implied. And I'm going to give some examples of what that means. So in everyday life, we use hearsay all the time. All the time. You say something like, yeah, I heard Bob say that he was hungry. Nothing wrong with that in everyday life. But in mock trial and in regular trials, that would be hearsay evidence if what you're trying to prove is that Bob was hungry. Because it's a statement that wasn't made at the trial. Bob is not there, so Bob cannot be asked further questions about the statement. And it's being offered to prove whether Bob was hungry or not. And so the reason that hearsay evidence is often excluded is because it's not the right evidence that can be genuine and that can be tested and that you can really make sure that what that evidence is trying to introduce is true. And so some other examples here, let's say Joe says, Anne told me she saw the defendant kill his roommate, and Anne isn't testifying at trial. So all we have is Joe's statement about what Anne told him. It's just not good enough. What we really need is Anne's testimony about how she saw the defendant kill his roommate. That's what's going to be valuable for the jury. But what Joe says that Anne told him, it's just too many degrees separated from what we actually need. And so that would be excluded. But then there are a lot of statements that sound like hearsay, but actually aren't. So some examples of that. When the testifying witness, so let's say Anne in this case, testifies, and she made a statement before that doesn't comport with the statement she's making at trial. So they don't match. In mock trial, you're going to have witness statements that will be written, that you'll know exactly what each witness's position is on the case. And then you'll examine them based on those statements. So it's not hearsay if Anne is on the stand and she testifies that she lives in the apartment next door to the defendant and his roommate. But let's say that in her witness statement, she had said that she lives in the apartment across the hall from the defendant and his roommate. So that's not hearsay because those two bits of testimony are inconsistent with each other. That could come in. Also, another statement that wouldn't be hearsay, even if it sounds like it, is when a statement is offered against an opposing party and was made by the other party. So for example, if the defendant in our case says that his roommate told him he planned to kill him in a week, so we've got the defendant testifying about what somebody else says, so it sounds like hearsay. But here, because it's a statement offered against the defendant and it was made, or I'm sorry, it was offered against the prosecution, but it was made by the defendant, that's not counted as hearsay. So I know I'm going through all of this very quickly. I know it's very complicated. Don't worry if it doesn't make total sense. It's something you'll be looking into a lot more as you start practicing for mock trial. So I'm going to take just a second to talk about some exceptions to hearsay. So again, we're talking about statements that are hearsay, but we can still let them in. And some examples of that, and I think there's something like 27 examples, but we're only going to talk about a few of the most common ones. A present sense impression. So this is something that could still come in even if it's hearsay. In this example, let's say Anne, the neighbor, says, "I heard the roommate say that's such an ugly lamp," right before he died. So it seems like hearsay because we've got Anne testifying as to what somebody else said, but what they're testifying to is what the roommate said in that moment. That's why it's a present sense impression, and that's something that can come in. Then we've got excited utterance. So let's say the neighbor, Anne, testifies, "I heard the defendant yell that he'd just stepped in a pool of blood." So when something is an excited utterance, meaning somebody says something in the heat of the moment, then even if it's hearsay, it can still come in. Statement against interest. And this would be anything that a party would have testified to or a witness would have testified to that they would not have said otherwise because it really works against them. So Anne, the neighbor, says, "I heard the defendant say, 'I can't believe I just killed someone.'" The defendant would have never wanted that to come into evidence. And so the fact that even though this is hearsay because we've got Anne testifying as to what the defendant said, it still can come in because the defendant never would have said it otherwise. It's so against their interest. If the declarant is unavailable. So in our case, we've got, say, the defendant refused to testify, and so we can't cross-examine that defendant. Then hearsay can come in if someone else needs to testify as to what the defendant said, because the defendant is unavailable. And finally, somebody's dying declaration can come in. So in this case, let's say the neighbor said that the roommate said, "I've been murdered," as he lay dying. It's definitely hearsay, but because it's something that the roommate said as he was dying, it can still come in because it can be shown to be truthful because people don't tend to lie as they lay dying. So that was a lot about hearsay. I'm going to move on from that now. And again, it is very complicated, but it's something that you'll learn more about as you're going along. So let's move on to objections. And we see lawyers objecting during trial all the time on TV and movies, and it's important to know when to object, how to object, and what kinds of objections to make. So one question in the chat, does declarant unavailable apply if the defendant pleads the fifth for self-incrimination? So it depends on what state we're in, and I'm not actually sure of the answer to this under the mock trial rules. But generally, yes, if a defendant decides to take the fifth and not testify on his own behalf, then the declarant would be unavailable for purposes of hearsay. So it's something that I would need to check on the mock trial rules to make sure that's true, but I believe that's true in this case. Okay, so objections. Typically, what you're doing when you're making objections is you're objecting to opposing counsel's questions and not the witness's answer. Now, there's some exceptions to that, but usually what you're objecting to is that opposing counsel asked a question that the only way to answer it would result in an answer that would be objectionable in some way. And objections should be made between the question and answer. That's often difficult to do because during mock trial, sometimes the question and answer of examinations will go very quickly. And so when you're the attorney who needs to be making objections, you really need to be thinking about them as you hear the question and try to get them in as quickly as you can. Now, a lot of judges, and myself included, when I'm judging mock trial, if that attorney can't get the objection in quite fast enough and instead they say it after the answer, I'll usually let that slide and I'll ask about the objection anyway. But not all judges will do that. Some will say you have to give the objection between the question and answer. Now, many or most questions that an attorney is going to ask could be deemed objectionable in some way. So what you have to think about, and this is a strategy decision for your team, is whether you want to object a lot or only when it really matters. And this is something that really differs, just again, depending on what your strategy is. There are different reasons for doing both. I'll say that having judged mock trial for a lot of years now, that attorneys who make a lot of objections can drag out the trial another hour, hour and a half, because the time stops every time an objection is made. And then we have to have a back and forth between both attorneys and the judge to rule on the objection. So it just depends. My general practice as a lawyer is to object only when it's really important to my case. I'm not the type who's going to object just to break up the other attorney's momentum, but a lot of attorneys think that's a good strategy. And in mock trial, it can be if, let's say, your witness is being cross-examined by the other attorney, and that attorney is getting your witness to admit to all kinds of things that really hurt your case, it might be good to do some objections to break that up, to make sure that it's not all running smoothly for that other attorney. So those are all things that you'll think about with your team as you're preparing for mock trial. So here's some examples of different kinds of objections that can be used during mock trial. So one is asking a leading question on direct. And anybody who was in my earlier session would know that leading questions are fine on cross, but shouldn't be used on direct. So an example here is, on the day of the murder, you were home, right? So that's a leading question. And if that question comes in during direct testimony, then if you're the other attorney, you can object to that question as leading. A compound question. This means a type of question that has two or more parts to it. So did you buy the lamp and a sandwich? Well, then what would happen if the witness just answered yes? We would have no idea if the witness meant that he bought the lamp, that he bought a sandwich, or that he bought both. It's open to interpretation, and so it's not good evidence because we don't know which way the witness interpreted that statement. So that's something that you could object to as compound because it has those multiple parts. You can also object when a question calls for a narrative. So for example, if you asked, what did you do on the day of the murder to the witness, that witness could launch into a narrative that could go on for an hour. Well, I woke up at 7, I made myself an omelet, I got dressed, I showered, I did this, I did that. There's nothing wrong with that exactly, but none of it is relevant to what we're talking about here. So that question would call for a narrative, it's too open-ended, and you could object to it for that reason. You can object to questions as argumentative. Something like, well, how can you sit there and lie to the court about your feelings for your roommate? You could say objection, argumentative, because the attorney has launched into their own opinions about the trial. They're trying to argue their case, and what they're supposed to be doing is asking questions and getting answers. And then asked and answered. You can object if the attorney is asking a question that has already been asked and already been answered because it's repetitive. So question, did you kill your roommate? Answer, no. Question, so to be clear, you killed your roommate? So if you're the other attorney, you would object to that and you would say asked and answered, because there's no reason to have that follow-up question when it's exactly the same question, just phrased differently. Some other types of objections, vague and ambiguous. And that's when a question is just so confusing that the witness wouldn't understand what it means. You don't understand what it means. You need it to be clarified. So a question like, when did you see it happen? Well, see what? We don't know what they're talking about there. You could object to vague and ambiguous, and then the other attorney could rephrase it to say, when did you see the murder happen? And then we know, everybody knows what everybody's talking about. We don't have to worry about it being vague. Calls for speculation. So we talked earlier about how important it is that witnesses have personal knowledge of the facts in the case. But in this case, if you ask a question like to the defendant of what was your roommate's favorite TV show, and the defendant didn't have personal knowledge of this, and the defendant had to guess, then it would call for speculation. So let's say the only way the defendant could answer this question is something like, well, you know, we never talked about that, but I saw him watching The Real Housewives of Dallas all the time, so I think that's probably his favorite TV show. It still calls for speculation because it's not a fact on which the defendant would have personal knowledge. Calls for expert opinion, and this is something we talked about earlier too. Something like, how did your roommate die? If you ask the defendant that, the defendant can't say, well, you know, he died from blunt force trauma to the head and this and that. That's all medical testimony, and that would all need to come in through an expert. So you could object to that as calling for an expert opinion. Calls for a legal conclusion. This doesn't happen as much during mock trial, but it can. We're not talking to lawyers here. What we're doing is we're talking to witnesses, people who actually have personal knowledge. So let's say the attorney asks, did you have the mens rea for murder? Well, mens rea basically means, did you have the right state of mind? But mens rea is a legal term, and it's something that the judge or jury is going to have to determine. That's part of their job. It's not something that a witness can determine. So you would object to that as calls for a legal conclusion. Now, earlier I said that usually you're objecting to the questions and not the answers. The one exception to that is when an answer is non-responsive. Then if you're the attorney asking the questions of the witness, you can actually object to the answer that the witness is giving as non-responsive. Question, weren't you the last person who saw your roommate before he died? Answer, I didn't have an omelet for breakfast. Okay, that has nothing to do with the question that was asked. And so you could object to that as non-responsive. And then the judge can tell the witness to answer the question that was asked. And then finally, our good friend hearsay back again. So a question like, did the neighbor tell you that the defendant told her that he killed his roommate? You could object to that as calling for hearsay because it's requiring somebody to answer on behalf of somebody else who isn't there in trial to answer that question themselves. So it would count as hearsay. Okay, so then we're going to spend a little bit of time, and actually I didn't do this correctly. Okay, we're going to spend a little bit of time now talking about specific questions, and I want you to put in the chat the kind of objections that you would make to these questions. So the first one, which I think everybody probably already saw, but we'll pretend it didn't. Let's say your opposing counsel asks your witness, did you see what happened on July 14th? What kind of objection would you make to that question? Did you see what happened on July 14th? And I'll give you a minute or so to put the answers into the chat. Okay, yeah, everybody's basically getting it. It's vague and ambiguous because it's not specifying what we're talking about. A lot of things happened on July 14th of any year. So it really needs to be a narrower question. It needs to say, did you see what happened in the roommate's apartment on July 14th? Did you see the murder on July 14th? Things like that, that would be a lot narrower and get to the facts in the case. All right, so the next one would be your opposing counsel is questioning somebody on direct. So they're asking their own witness questions. And the opposing counsel asks their witness, you knew the defendant didn't have a car, didn't you? What would be the objection you would make to this question? Okay, great. So it's a leading question. And as we know, you can't ask leading questions on direct. That's not something that is permissible under the rules of evidence. You can ask all the leading questions that you want on cross-examination, and that's a good way to do it. But on direct, you can't do that. Okay, let me just take a second, make sure I have what I need. Okay, the next one would be if opposing counsel says, how did the defendant respond and react when you saw him standing next to the body? So opposing counsel is asking, how did he respond and react when you saw him standing next to the body? What kind of objection would you make to that question? All right, so this one's a little trickier because there are a couple of different objections that we can make here. Number one, it's a compound question because it's asking how the defendant responded and reacted. So if the answer to this question was, well, he sneezed, then are you saying that that was how he responded or how he reacted? It's a little confusing. It's not a clear way to do this. The best way to ask a question like this would be, how did he respond? And you could say, well, he didn't say anything. He didn't respond. How did he react? Well, he sneezed. And then you would get the testimony you actually need. It's a lot clearer. But this could also be a hearsay objection because you're asking a different witness, not the defendant, but you're asking somebody else what the defendant did or said. And so that could be a hearsay objection as well. So the next one, let's see if opposing counsel asked the question, and we saw something similar earlier. What did you do on July 14th? How would you object? So again, what did you do on July 14th? Okay, great. Everybody's narrowed in on it. There's a couple of different objections that you can make here. First, that it's vague and ambiguous because what do you mean, what did you do? I took a shower, I ate an omelet. None of that matters. What we're really talking about here is what did you do during the time of the murder on July 14th? We're not talking about all these other things. It also calls for a narrative though. And so it risks the witness launching into a play-by-play of everything they did on July 14th. So it wastes everybody's time because there's a lot of irrelevant evidence that comes into play there too. Okay, the next one. Let's say your opposing counsel is, I think I got that wrong. Yeah, so let's say opposing counsel is cross-examining the defendant. You're representing the defendant. And opposing counsel asks, wasn't it heartless of you to leave the roommate lying in a pool of blood? How would you object? Yeah, good. I think everybody's got that one. It's argumentative. It's argumentative because it is basically that attorney testifying as to what they believe and trying to get the jury to see the attorney's perspective. But the jury doesn't care about what the attorney's perspective is. What the jury needs to hear about is what the witness has to say about this. All right, next one. The opposing counsel asks, what's your cat's name? In our case, there's no cat involved. How would you object to this one? Yeah, everybody's got it. It's irrelevant. It's irrelevant because there is no cat at issue in this case. And so what the cat's name is, unless the counsel can really tie it to something, and sometimes that's what you can do, is say, you know I asked this question, it sounds irrelevant, but I promise I'm about to tie it to something that is relevant. Unless they can do that, then this would not come in. The next question from opposing counsel is, no, seriously, what's your cat's name? How would you object to that? Yep, great. It's still irrelevant, but now it's not only irrelevant, it's also been asked and answered. And so it would get excluded on one or both of those grounds. Okay, the next question. Opposing counsel says, what did the roommate say to you as he was lying there dying? How would you object to that? Excellent. It's a hearsay objection, but it would probably fall under the exception to hearsay for the dying declaration, because it's what the roommate was saying as he was dying. So basically what would happen is it would be correct to make an objection for hearsay, but then opposing counsel would say, this falls under the dying declaration exception and should come in. And the judge would probably let it in anyway, but it is still a hearsay objection. Finally, here's the last one. Your opposing counsel is asking the eyewitness, how did the roommate die? How did he die? Now, this is an eyewitness. We're not talking about a doctor or anything here. How would you object? Perfect. Calls for an expert opinion. And that's because the eyewitness saw what happened, but they're not a doctor, they're not a scientist. They can't give their opinion about the cause of death. So that's it, calls for an expert opinion. All right, in the couple of minutes we have left, I want to talk quickly about how to make objections in mock trial. So when you hear a question that you think is objectionable, then you would say objection, or you can say objection speculative. You can do it either way. And if you don't give the basis, so speculative would be what we call the basis for the objection, then the judge is going to ask you what the basis is. And then opposing counsel will get to respond, and then the judge might ask you to respond to their response as well. And then the judge is going to make their ruling. They're either going to overrule or sustain the objection. And what that means is if the judge sustains your objection, then it means they agree with you that that is objectionable and that the question has to be withdrawn. If the judge overrules your objection, that means they agree with the other attorney that the question was okay and that the witness has to answer the question. So that's the difference between overruled and sustained. Sustained is good for you, overruled is good for the other side. If an objection is sustained, then the other counsel can try to ask the question differently if it can cure the objection. So let's say that opposing counsel asked the question, what's your cat's name? And you object to that question as being irrelevant. And then the other attorney says, well, I'm going to tie this to a relevant question in just a second, because what the cat's name is it goes back to whether the defendant and the roommate had a disagreement about what to name the cat. And that was why the defendant murdered the roommate, something like that. Then you might be able to cure the question because you're tying it to something relevant. So here's how it looks in practice. Opposing counsel asks the question, what was the defendant thinking that day? And you say, objection calls for speculation. Opposing counsel says, it doesn't call for speculation because the defendant told the witness what he was thinking that day. In that case, you can say, well, now it calls for hearsay. You can make another objection. But let's say you don't. Let's say that's what you and opposing counsel have argued. Then the judge would say sustained, and then opposing counsel would have to drop that question and move on. So that's basically how objections work when you're going through mock trial and you're going through the examinations. And you'll get a lot of practice at doing objections and seeing other teams do objections as you're practicing and as you're competing. So I think we've got about 1 or 2 minutes left. So if anybody has any questions that they want to put in the chat, I know I've just dropped a ton of information on you, but if you have any questions, I'm happy to answer them in the time we have left. Okay, we've got the question, what is the most common way that someone gets objected to? So in mock trial, I would say the most common objections tend to be speculative because a lot of times witnesses will try to testify to things that other witnesses really should be testifying to because they don't have that personal knowledge. Also relevance. When you see the case problem and all the witness statements, you'll see that a lot of those witness statements have a lot of information that really isn't relevant to the case. And so there might be testimony and question and answer going on that's correct in the sense that it's in the witness statement, but it's just not relevant. So you would get that objection to relevance. I'd say those are probably the two most common that I see. Got the question, how many objections are there in a case? Whew, it really varies. I have probably judged well over 200 rounds of mock trial, and I would say it ranges from 0. I've definitely had trials where nobody objects to any questions at all. And I've had trials where there are probably hundreds of objections. It really just depends on the teams and what their strategies are for making objections. A lot of times what will happen also is that one team will start objecting a lot, and so the other team will also object a lot because they don't want the jury to think that they're the only ones asking objectionable questions. They want it to be even that way. So yeah, like I said, I've definitely seen it range. I'd say typically you might see 2 or 3 objections per witness. I'd say that's most common. Can I share these slides? I would be happy to. I'll talk to Melissa, who's running the clinic, to see if that's something we can do. And when she sends out the case problem and the other information to everybody, I'll see if she can attach the slides too. Any other questions? So what if the attorney doesn't object in a question? Will the judge still take points on the team if it doesn't follow? Possibly. That is something that the jurors will be looking at when they are judging how the teams are doing. If the other attorney asks a question that is really objectionable and it's very important. So let's say the attorney is asking the neighbor, how did the roommate die? And the other attorney doesn't object to that question as calling for an expert opinion, then that would really be damaging to the case if the neighbor says he died from blunt force trauma, because the neighbor is not qualified to give that opinion. The neighbor is not qualified to do that. So that kind of thing could be something the jury members would take points off for, because there really should have been an objection made there and it wasn't, and it was important. At least when I'm doing it, that's what I look for, is not so much could there have been an objection there, because like I said, almost every question can be objectionable for some reason. So it's not could they have made an objection, but should they have? And if it's something like asking a lay witness, how did he die? Then that's something that I would determine should have been objected to, and I might take points off for that. Next question, for mock trial, how does the jury work? They'll connect virtually. I think so. I don't actually know yet how this is all going to work remotely. I know the committee is working hard on getting that figured out, but I think all of us will know the answer to that question at the same time when they actually start making, start putting out information about what that's going to look like. So I think we're over time. They're not pulling us back into the main room yet, but and I don't actually know if we're going back to the main room or if we're just done at this point. So if anybody has any other questions, I'm happy to hang out a little bit longer. We're either going to get pulled back into the main room or else we're done for the day. But like I said, I'm happy to hang out in this room for a few more minutes. And if anybody has questions, that's great. And I just want to wish everybody luck this mock trial season. It's going to be a very strange season having to do everything remotely, but I still think it's going to be great. I love judging mock trial. I love seeing how far everybody comes throughout a mock trial season, and I really wish everybody luck. So thank you very much.